Yeah, hi small business owners, it's Harpreet Singh from Sharon Law Firm. So today, the last video of our small claims court series, it's about collections. As in the last video, we had discussed that suppose you get a judgment. Now what's the next step? Because the court will not provide you money which is in your judgment, or court will not collect on your behalf. So what are the next steps? So especially when you have a judgment, you will usually receive that in mail. You will receive a notice of entry of judgment document signed by clerk, and so with that the debtor has different options now. Debtor has 30 days to pay you, and that's the usual for the small claims. So either debtor pays you, or debtor have the option to file an appeal within 30 days. Or if suppose the debtor has not appeared during the trial and you have a default judgment, so the debtor has an option to file a motion to vacate that judgment. If suppose debtor doesn't even do that, and also there is another option, the debtor can provide you a piece of document or a form which would provide assets of the debtor, and usually that needs to be given within 30 days. If you are, suppose you don't want to pay it now, so that's required by law. However, it's not been given usually by debtors, because once they have it, either they are in bad financial condition, they don't care about your judgment, they already have some other judgment, they have bad credit, so they don't care, and they will usually not send you that piece of document. So in next few minutes, I will explain you about what you can do about that. So you are in this situation where you're just waiting for the judgment. The another option the debtor can do is request the court to set an installment payment plan, which is not usual with other judgment with the civil cases, but usually I think you would also like to get paid, even if it's I think for some amount of time in future. You would, I think, need that certainty that you will get paid. Someone is promising you, they are approaching the court, okay, I will make this payment, $1,000 a month, $2,000 a month. They can request the court. There are different forms for that. And obviously, the debtor needs to also provide you the copy of that form for request for installment payments. And if you want to object it, you have 10 days to object it. You can again send the letter to the court that I don't agree with this, because possibly the debtor has some good assets, or they have a business and they are making good money, so it doesn't make any sense that this debtor should make these payments over like 3 years time. So you can obviously object, and then court will review that and provide their decision. Either the court agrees with you that they should pay in 3 years, 2 years, or 1 year, whatever is the time frame they are requesting. So that's one of the options the debtor has. So let's come to the I think the issue about if suppose debtor don't want to make the payment, they have to provide you information about their assets. Unfortunately, they don't provide you that. So what's the step? Means, because to collect, you just want to know the assets of the debtor, on which basis you will be able to enforce this judgment. So to know the assets, one way is that you do your own research, and either you know that the debtor owns a business, or they are an employee at some firm or at some company, or sometimes, and usually nowadays, because the main asset is real estate, which have lot of value in it now, especially the equity part of it. So you can research about, is there any real estate which this debtor owns? So you can do that research either through your county, or ask a real estate agent, because real estate agents have access to this MLS system, where they can also research about properties, about ownership of I think any kind of property they have in county. So basically you provide the name or little bit of other contact info, and they can provide you the information. The next step, you can just go to a private investigator who have also some systems in place. They have some subscriptions with different providers, which are like property maps through Thomson routers. So those systems provides you more information about asset of a person based on their personal information, if you have that. If suppose you are not able to find any kind of information about this debtor, suppose this debtor is a self-employed person who doesn't own any home, they are on a rental property, and you don't think they have any kind of assets. First you have to think about if they don't have any kind of asset, then it's unfortunate part on you that you would not be able to enforce this judgment anytime soon. That doesn't mean that your judgment will not worth anything, because maybe in future, as you have seen, people who have lost values in their assets in 2008, now those assets have recovered in around 2013, 14, 15, and they have value now, I think about, at least we can say 40% more than 2008. So you never know how time changes. So the best part of your judgment is that you have a judgment which is valid for 10 years. So for 10 years you can keep on looking the asset of this particular debtor. You don't have to give up. You just have this judgment, it's sitting around there. Another best part is you are getting interest on that. So the time frame which you are putting, it's not wasted. You are getting an interest, and on top of that, whatever expense you spend to collect on this judgment, you can recover those expenses, like expenses for a private investigator, or expenses you have to spend, suppose on some attorney advising, or what to do with the next step. So those kind of expenses you can able to recover, or especially the expenses where you have to file different kind of forms. So I will just talk about those different forms for different assets. So you can also able to recover that in addition to the interest part. So you're not losing much, but you're not getting that it sooner, which you're thinking about. And it's small claims, so you can think about it's not much amount at max. Probably the court has awarded you $10,000. Yeah, that's a big amount. But if it's $5,000, so it's not a kind of amount which your life will stop if you will not get it. But you have to just make constant effort towards it to find the assets of this debtor. So you have this option of researching on your own. If suppose you are not able to find anything, so there is another option for debtor's examination. So you can ask the court to have a hearing by filing. Obviously there are different forms for it. It's application and order for debtor's examination. So you can ask the court to have a debtor's examination set, so that the debtor can come into court, and under oath debtor can answer the questions which you have about different assets of debtor. So you can also send the subpoena with that and ask debtor to provide copies of his bank statements, which he presently have, any active accounts, or if he have any real estate. So you can ask those questions, and debtor have to provide the honest answers of those questions. If you think debtor is not cooperating, so probably you can get the judge involved in the process, and the judge will instruct the debtor that you have to answer these questions based on this procedure. But there have been many times which when I was volunteering with the small claims clinic as a law student, so I have seen the debtor don't show up for these kind of hearings, because possibly this debtor, the credit is not good, and they don't care about further judgments. They already have some other big judgments. So what option you have if they don't show up? So you can request the court that obviously it's contempt of court and the sanction should be awarded. The court can also issue a bench warrant, which is usually not at first instance, but court can issue that. That would probably would force in the debtor to just show up in the court and provide this information. So it just depends on your debtor. If your debtor is cooperative, obviously you should, I think, get the info and try to resolve your judgment. Either it's through payment plan, that's always good. Because to force in the debtor, sometime debtor may file bankruptcy. If they don't have any asset, then unfortunately your judgment would probably get discharged in the bankruptcy, and unfortunately you will not be able to recover anything. So you have all these options to think about before you start any collection process. So it's pre-collection process step which you have to think about. So again, the main thing is that you need to know the assets of the debtor. You need to do research or use this debtor's examination process to know this information. So once you have the information of the debtor, suppose you know where debtor works, you know the employer information. So there is a procedure to collect, or I think so-called, you just remember is as wage garnishments. So basically you are able to collect some amount of wages from the employer of the debtor in terms of enforcing your judgment. So to do that, first you need from the court a writ of execution document. So basically a writ of execution is instructing the sheriff of local county to provide them with force of law to enforce this judgment. That's the main purpose behind writ of execution, that you have this, that sheriff gets an authority to enforce the judgment. And with the wage garnishment process, once you get a writ of judgment execution, it's just it's just a piece of form about a couple of pages, and with that you just attach your entry of judgment copy so that the clerk will know what you are asking about for which case, and based on that the clerk can issue you a stamped copy of the writ of execution. So once you have that, you need to provide instructions to the sheriff of your local county, and they have different fees about that because each sheriff have different fees, so you have to just research from the sheriff's department. So you provide writ of execution document, and also there is wage garnishment forms which you have to provide, and also an employer have like kind of instructions for the employer, which usually the sheriff, I think it's always good to print those. So you just provide instructions to sheriff, okay, this is the employer, this is my judgment, and this is the time frame this person he works here, either part-time, full-time, whatever is the situation, if you know about it obviously. So you just provide your judgment amount, and they provide these documents to the employer with a notice. Then the employer have certain amount of days to provide you money which is mentioned in this writ of execution document. There is also exemption which the debtor can file with the court, because you cannot take the whole pay stub of the debtor, because the California law doesn't allow you that. There is certain percentage of the amount you can take. Beyond that you cannot take, because ultimately, even I think with your own logic you can think about, if you just take the whole paycheck, so how this person will survive with his living expenses. So there is only certain amount you can take. Above that you cannot take certain amounts, and there are different exemptions. If you can go on the courts.ca.gov website, they have, I think, laid out in pretty much very detailed manner. So I think in this video I would not be able to cover, like there are some detailed instructions about that. So my purpose is only to provide you, okay, these are different ways, and these are basic steps you can take to achieve your goal. So you can check courts.ca.gov website, go to self-help menu, and there is small claims. It provides you, I think, all the information which I'm talking about. So whenever you want to just do the collection work, you can do through that process, or if you need any advice, sure, you can contact any legal professional. So for wage garnishment, you can have that option, and over the time, how much time it would take to recoup your judgment amount. So you have to wait for that much time, but obviously you're getting, I think, the amounts, which is always good while collecting, instead of just sitting there and thinking about, I will just collect like $10,000 in just one shot. So that's for the wage garnishment part. And next, there is another option, means you can get the money from a person's bank account. So you can levy the bank account, because levy is the technical words used. So what you have to do for that, obviously the first document is that you need to have a writ of execution document from court. It's again provide that authority to the sheriff to enforce this judgment. And next, then you have to think about a notice of levy, and also instructions to the sheriff. So the instruction would provide obviously the name of the bank, and if the account number, you know about any account number from this particular bank, and the amount. And also, if you know about what's the time frame it's opening, you can always research online, okay, the branch is open. So there was a change in 2012 or 13 in California law. Previously, what you have to do, you have to research the debtor's actual bank account, means the actual bank account where and also the branch where this account is open, the original opening of this account with which particular branch. It's really hard, means if suppose you receive a Bank of America check, maybe in past from debtor, so now you know that he have an account in Bank of America, but I think it's very difficult to know, because sometimes people don't print obviously their branch names or branch addresses. So in that situation, it's very difficult to know in which branch this person has opened the account, because before 2012-13 that was the law. So but in 2013 the law changed, and for good. And its change, you just have to provide, suppose Bank of America, just only to one particular branch. If you don't have information about the opening branch, that's fine. You just have to serve your writ of execution, notice of levy documents. The sheriff needs to serve those to just a particular branch, and then they have the duty to research about based on the name. And also, if you have the account number, that's good. Then based on the account number, okay, how much is the funds available in this account, and then they just put a hold on those funds and start preparing for a levy. If suppose, if you have followed the old way, if you have sent to one branch, they can just reject it. Okay, we don't have this account. But I think it's really very good. The law has changed since then. And also, you have to make sure you just go on the California state's website, and it provides you the list of all the banks, which provides a centralized location. So with this centralized location, if suppose a banks provide that, and most of the banks, especially the nationalized bank like Chase Bank, Wells Fargo, usually they don't have the addresses. But the banks which are like kind of regional banks or credit unions, they have a centralized location which is on this website. You have to just go there, see that location, and that's the location where you have to serve. So if suppose you get a judgment in San Joaquin County, and this centralized location is in Los Angeles County, then you cannot ask the sheriff of San Joaquin County to serve document in Los Angeles County. So you have to obviously get a writ of execution and ask the sheriff of Los Angeles County to serve those documents to that centralized location. So then only that particular bank will be able to provide you the levied money, if there is some money or if that account exists. So obviously, again, the person have a right of filing an objection to it for some of the amounts, because some of the amounts are exempt. You cannot just take it with your writ of execution. Those amounts may include disability pays, your social security, or some other amount. There is a great 2-page list of these exemptions. So probably you need to just go on courts.ca.gov website. It provides you that particular form and the details. So again, that person, the debtor, has the option to object it based on certain exemption. Then there would be a hearing held, and you will object based on what are the facts and the arguments they are making. So after that hearing, the court will decide if these funds are exempt or not. So this is about the bank accounts, how you can get the money from a bank account. So next is about the real estate. Obviously, you can put a lien on real estate if you have a judgment. So what's the process of that? The process is somewhat simple compared to the other option of garnishing wages and levying the bank account. Obviously, because you are getting liquid assets, obviously you are getting that cash upfront. So there are more steps. That's not, I think, the way of thinking, but still, if you can think, it's easy money. It's cash money you are getting from these two options, and there are more additional steps for that. So to put a lien on real estate, and it would be just a lien, so you have to get an abstract of judgment document from the court. You just file this form, court stamps it and provide you this piece of document. So what you have to do, you have to go to the county recorder's office, and obviously you first need to research if this person have this a real estate in this county or not. So once you have this abstract of judgment, you just go to county recorder's office, you just record abstract of judgment document, and once that's happened, so the county sends a copy of this abstract judgment to the debtor. So debtor knows now that you have filed this lien, and it's always good. It's just because the debtor then becomes serious that now I have a lien on my house or some business property or some other real estate, and it's attached to it. Interest is increasing, and it's there until the property is sold. Once it's sold in escrow, as you know, when you have bought the house or sold the house, the escrow contact each lien holder to ask for their demand, and the escrow will contact you once they will be selling the house or their other property, which they have this abstract of judgment lien on. And now the good thing is that you would be able to recover the interest on the base amount of your judgment. You can now add the interest and provide that demand to the escrow company. So it will take time. You don't know when they will be selling it or not. Another option is you can do foreclosure, and it's, I think, only good if there is great amount of equity in the property after paying off all the loans, which are usually purchase money loan or some kind of mortgage. So you have to also make sure there is another protection for debtor against these kind of outside civil judgment, which are called involuntary judgments or involuntary liens. So a homeowner has a protection called homestead exemptions, which are usually based on if it's owned, if the wife is living or husband is living, both spouses are living at the same property, and so it depends on that status. So it's at least about $70,000 plus it could be $100,000. So you have to just figure out if there is great deal of equity even after paying all the purchase money loan, because if you are thinking about to do a foreclosure on this property, then you have to think about all these calculation. How much is the current mortgage? You can get that information from county or from some title company. You can ask title company to provide you a preliminary report which will provide you all the liens and other burdens this property has. And also you have to think about this homestead exemption, because you cannot foreclose if after paying all this stuff and still you have this homestead exemption of this debtor. You cannot foreclose as it is if the equity is not above the homestead exemption. So there are like different options you have to think. Obviously, it's always good to consult with legal professional when you are getting into that kind of little bit of complicated things to collect. So, but there is an option if you know real estate about some person, and it's, I think this is one of the easiest option you can have. You just get one document, you file with a particular county. If suppose there is some other property in Los Angeles County, you have a lien from San Joaquin County. Obviously, you have to file that abstract of judgment in Los Angeles County. So you have to file that abstract of judgment in each and every county where you think this person has real estate. Next, there is also option of if you want to put a lien on a personal piece of property. If suppose they have like this equipment in their business or some other kind of item which they have, and because most of the time it's usually business, because businesses have like more asset or valuable, I think, things, and these are personal properties. So again, you have to do abstract of judgment, and there is little bit of, I think, complicated procedure, and also the fees would be more by sheriff. So if you need more details, probably you need to again consult with the legal professional, and I think if I just discuss that, it would be like another 30-40 minutes. So but there is an option if you want to put a lien on personal property. And the last, I think there is another thing which you can do. If you think there is a lawsuit filed by your debtor, some personal injury lawsuit, or some any kind of lawsuit like a breach of contract. If they are a business owner, they have filed a lawsuit against someone and they're asking money from some other third party, and you know about that lawsuit, what you can do, you can put a lien on that lawsuit. So if suppose plaintiff obviously he would be plaintiff, your debtor would be plaintiff, because otherwise how he will be getting the amount. So if you know that, then you can put a lien in that lawsuit. So if your debtor gets money from that lawsuit, any kind of award or settlement, so your debtor have to provide you this money, because you have the judgment filed with, you have this lien on this particular case award filed with the court. So obviously that's another option. If you think there is some lawsuit, you can research that. You can go to the court, either the court clerk's office, there is self-help centers, or you can usually nowadays you have the good systems which the courts are developing. So online you can search, put the name of the debtor and search if there is any case of this particular debtor in this county. So if you think maybe 2-3 counties this debtor works around or have a business in, you can search in these 3 counties, and then you would be able to know if there is a lawsuit. Then you can follow the process of abstract or judgment, and then you can just file a lien on a possible potential future award. So there are like different options, and this is also applicable to general civil cases. With small claims, there is little bit procedure after the entry of judgment, some special procedure. But with other civil cases, the process is the same. These are like different options, which is almost somewhat same. So if you have a civil judgment, so these are potential options you can look at. or you can always get consultation with your documents with a legal professional. And again, I think it has been a good series. Probably I have provided you more information, and probably you have got more knowledgeable in terms of small claims procedure and what kind of claims you can bring, how you can bring the claim, what you have to do before your hearing, at the hearing what you do, and what are your options if you lose. Either you are a plaintiff or a defendant. If you have an award, then what you can do. So I think these videos would have provided you some basic legal information on all these topics. And obviously you can always also get help from each and every county has a small claims hotline, because they get some part of funding from courts to run that. But sometimes it depends. Some counties doesn't have, I think, that much of a good system. They respond to you like after a couple of days, you just leave the message. So but you have different options to think about. So if you have any other legal questions, want any general legal information, you can always comment. So I'm always there to think about what people send us comments or anything we hear about after having multiple consultation over the weeks. And so what would be a good topic where people want to know more information about, and what would be a good help for people. So that's our main aim, always to bring good content where you can get some knowledge and we can share few things with you about court system, about our judicial system, and how you can navigate that. And also in situations where you're not able to figure out, then obviously you need to have a legal professional to go through your stuff and just craft your goal to you. So thanks again for watching these videos, and in next videos we will come with again another interesting legal topics and talk about, I think, the most important thing, which obviously you have to take care when you're in legal trouble. Thank you.